Hello and welcome to Friday Live. I am your host, Strata lawyer Amanda Farmer. We're heading out live this Friday afternoon to the Your Strata Property Facebook page. Hello, all of you Facebookers. We're also going out to my LinkedIn profile. We are on YouTube. I am here for your wrap up of the week in Strata. What are the hot topics that we need to be talking about this week, making sure that we haven't missed maybe some discussion points that we want to go a little deeper on. I'd like to hear your views. I'm going to share a little bit more about what I think. That is what Friday Live is all about. And it is an opportunity for us to come together, to catch up, to celebrate another week in Strata. Because if you can get through a week, you can get to Friday, still be here and still be okay and still be smiling. I want to celebrate that with you. Another busy week for me, no doubt it has been for you too. I am back in my home studio, having less than 24 hours ago been in Sydney. Specifically, I was in Rhodes for the City of Canada Bay Council. You might have heard me mentioning that one this time last week, and also here on the Facebook page. Excellent event hosted by the City of Canada Bay for their very lucky apartment residents. We were talking about strata committees, how to have a high performing strata committee. My tips. It was a packed house. There was not a seat left in the place last night. Lots of eager residents turning up, giving up their Thursday night to come and learn more about strata and strata law. In addition to my presentation, a really helpful, really thorough presentation from Gareth Huxley, all about electric vehicle charging and the steps that communities might want to be thinking about now if they're thinking about EV chargers and planning for the future. I got a lot from that presentation as well. And it was lovely to see some of your faces. Some of you in the audience telling me that you tune into the podcast, tune into live, a couple of Strata Manager supporters there as well. It was a really fun night, and I hope I can do it again sometime soon, perhaps coming to your local council area. If you're here live, I love to see those hellos coming through. Jeff Hallam is here, man of the moment. Hey, Jeff, how are you doing? So glad that you could join us. You are getting a special mention today. I know you don't mind me saying so. Petra's here. Good afternoon, Petra. Hey, Sean. Good afternoon to you. I hope all is well in your world. Cassie, lovely to have you with us. Cassie, welcome. Vivian is here saying good afternoon. Josephine is here. Hello, Josephine. How are you going? Excellent. Lots of eyes here live. If you're not here live and you're catching the replay, which sits here on our Facebook page, on LinkedIn, on YouTube for a little while, welcome. Special welcome to you too. Feel free to give me a hello. Always like to see who is tuning in, just like David Glover. Hey, David. How are you going? Welcome. All right. So I'm going to have a revisit to this week's podcast, a revisit for me, but perhaps you haven't listened to this week's podcast yet and you want a little heads up what we are talking about on the pod this week. I'm going to give a nod to a bit of media that has been doing the rounds this week. Maybe it's strata related. Maybe it doesn't seem strata related, but I'm going to tell you how it is strata related. And I'm going to do a deep dive, as I like to do often here on Friday Live, and you tell me you love a deep dive into a recent tribunal decision. And because we are such a generous community here, always wanting to learn from each other and always wanting to share, I have the privilege of receiving decisions from the tribunal from you that you send to me, that you have been involved in, whether as owners, as agents, as representatives, as strata managers. You send them to me when they're hot off the press and say, Amanda, I think this would be a really great case for your audience. And I'm always thrilled when I receive those emails. So keep them coming. That's what I have for you today. One of those cases that I think is going to be really helpful to the many of you. I know from being in our member forum, answering questions the last few days, there's a few of you who are involved in your own tribunal applications at the moment and could really benefit from seeing one of these applicants that has been successful in a repair and maintenance case in particular. This one, I know when I take you through it, will tick a lot of boxes for you if you are putting together or thinking about putting together or in the middle of one of those claims. Marianne is here. Good to see you, Marianne. And Kristen, thanks for another Friday Live. Thanks for being here, Kristen, for another Friday Live. Great to have you with us. That is what is on the agenda for this week. We may be here for half an hour, 45 minutes, possibly up to an hour or so. That is how we like to spend our Fridays from time to time. So welcome. Get comfy. Strap yourselves in. This week's podcast is actually episode 400 of the podcast. 400 episodes. I still remember very clearly. This is how I know it was 2016. It was around about this time of the year, March, that I started the podcast because I remember very clearly attending the annual conference of the Australian College of Strata Lawyers, which always happens around March each year. That year, it was at the Intercontinental in Sydney. And I remember taking a break from proceedings and sitting in the lounge at the Intercontinental and listening to the edited version of episode number 1 that my then editor had prepared for me, and thinking, we're about to press publish on this. I don't know if it's any good. I don't know if anyone's going to like it. I don't know if anyone's going to listen to it. That was 8 years ago. 8 years and 400 episodes ago. So I was very lucky to be able to share episode number 400 with Rena Van Alst, Strata manager from Strata Central, my very often co-host. Rena and I like to produce an episode, if we can, at least once a month, if we're organized, and cover our wins and challenges in Strata. And that is indeed what episode number 400 has been this week. So if you've had a listen to that one, I would love to hear your thoughts on any one of these topics that we covered. If you haven't yet listened, there's a link here for you in the notes. We talked about a lot, a little bit longer than usual this episode. Rena shared her challenge first up, and she started by asking me who is responsible for paying what ended up being a $10,000 excess on an insurance claim that came about because a flexi hose connected to a lot owner's dishwasher, I think it was, had burst in the apartment, leaving a flood behind. And that owner had installed floorboards, or that lot had floorboards installed, not original. They'd been installed at some point in the past. The floorboards were ruined. It was quite a cost to have those repaired, and the owner was insisting that the owner's corporation make a claim on its building insurance. Rena was telling me that the excess was $10,000. The building was happy to make the claim, but the question was who should pay the excess in this situation, and was there a way, Rena was asking me, to require the owner to meet the excess, or the owner to pay part of the excess, maybe half. And that turned into quite an interesting discussion. We not only talked about whether or not the owner's corporation could legally recover the excess from the owner, but we went on to talk about whether or not the claim should be lodged in the first place. Being an issue that didn't relate at all to the common property. It was an unfortunate event, but a flexi hose attached to a dishwasher, or often attached to a bathroom or laundry sink, if that bursts, that is lot property. There's no failure in the common property. Interesting that building insurance policies do cover. They usually do cover these kinds of things, but does that mean the owner's corporation has to lodge a claim, especially when it's going to be facing a huge excess? Kristen saying, given it was a lot owner caused damage, that lot owner was very lucky. Yes, well, there is a comment under this episode over on our website, and you are always welcome to head over to the website, even if you're getting your podcasts through Apple Podcasts or through Spotify. I know a lot of you tune in that way. Every podcast episode, all 400 of them, are over on the website. That's at yourstrataproperty.com.au/podcast. podcast. You'll find all the podcasts there. And that's the place to go to get the transcript for every podcast, to get the links to any cases we might talk about, any legislation, any other resources. They're all there in what we call the show notes under the podcast episode. It's also the place to let Rena know your thoughts on what it is that we are discussing. And there is a comment over there that I think was posted yesterday by a listener. That listener's name is Alex. That comment is there publicly for you to go and have a look at. But Alex is saying this was a very relevant talk about insurance claims. We have a similar case, says Alex, where a lot owner's apartment was trashed by the tenants. There was no common property involved. The lot owner, without letting the Strata committee know, got the Strata manager to make a claim on the policy. It was approved to do works worth $13,000. And guess what? The excess was $10,000. The owner requested $13,000 in lieu of the works. I assume requesting $13,000 from the insurer in lieu of actually having the works done, claiming that he would do the works himself quicker, and he pocketed the money. Were any of you out there as surprised as I am hearing this? The lot owner was able to instruct the Strata manager to lodge an insurance claim without the Strata committee knowing anything about this insurance claim being lodged. That to me is the first question mark in that scenario. And I can see Kristen, that shocked emoji there. A Strata manager should not, in my view, be taking instructions directly from a lot owner to lodge an insurance claim. The owner's corporation is the policy holder. The owner's corporation is the one lodging the claim, and the Strata manager gets their instructions from the owner's corporation. The Strata committee is the representative of the owner's corporation in that circumstance, and those instructions should have been coming from the Strata committee. An insurance claim should never be a surprise to a Strata committee. So this lot owner, $13,000 worth of damage in their apartment because of tenants, damage that tenants have done. Again, very surprised that is an insurable event under the building policy, but the insurer has responded and paid out, it sounds like $13,000 to the lot owner. Now, Alex goes on to say in the comment, and this isn't all of it, do head over and have a look. When the committee found out about this, the committee resolved to, Alex's words are, rescind the claim. Maybe that's withdraw the claim, or I'm not exactly sure how that would work once the claim's been paid. But the decision was to have the owner reimburse that $13,000 to the owner's corporation. There were then 2 consecutive general meetings where resolutions were made confirming that the owner must reimburse the $13,000 to the owner's corporation. Sounds good to me. Now the case is in NCAT. The case is now in NCAT. So almost exactly what Rena and I were talking about there. Whether or not a lot owner can force an owner's corporation through an NCAT order. We talked about a section of the New South Wales legislation that I think a lot owner might be able to rely on to force an owner's corporation to lodge an insurance claim. Whether or not that application would be successful would depend on the circumstances. But really interesting that hot off the press, that podcast, and immediately someone's had a listen and said, that's my experience. That has been happening in my community. I'm just seeing here, Josephine, I'm going to bring this comment up on the screen. Josephine saying, we were told we could not look at an insurance claim due to privacy. Wow, that blows my mind. So Josephine, I'm assuming that you're a committee member and insurance claims have been lodged by your Strata manager on behalf of owners who have suffered loss pursuant to insurable events, and you as a committee member are being told by your Strata manager that you can't look at an insurance claim due to privacy. That makes my head hurt, I have to say. I'm aware, Josephine, through another communication, which I have seen, I will tell you, that you may not be in New South Wales. Yes, I'm seeing that pop up now that you're in Victoria. I'm not sure if the rules there in terms of access to records, privacy are similar in Victoria as they are in New South Wales, but that wouldn't fly. In my view, that wouldn't fly in New South Wales. Kristen saying, while we're technically policyholders as lot owners, Surely it's polite to let your strata committee know. Yeah, interesting point there, Kristen. And look, I'm not an insurance professional or expert at all in this discrete area, and an insurance professional is definitely a good person to talk to about this. When you say that the lot owners are technically policyholders, is there a clause in the policy that makes that clear so that lot owners can directly make claims? And maybe that's what happens when these things go under the radar, under the strata committee's radar, when these claims go in without the strata committee knowing about it, an insurer is just accepting them because they're lodged in the name of the lot owner without any sign off. But I would think something would need to be signed off by the committee or by the strata manager, have the owners corporation's seal, for example, and no strata manager should be affixing seals or signing things in the name of the owners corporation without owners corporation instructions to do so. Vivian saying, has anyone read the New South Wales discussion paper for Strata? STRA? Would that be short-term rental accommodation? Submitted their submission. I'm not sure what that one is, Vivian. Let me know. Vivian, are you in New South Wales? And if you have a link for that one, let me know. That's a short-term rental accommodation discussion paper that's going around. To the extent it's relevant to Strata, please do drop a link here for us. Sean is saying, hello, Sean. I don't know if I've said hello to you yet. Welcome. Sean is saying, if owners are jointly and severally liable for debts of the owners corporation, wouldn't they also be jointly and severally parties to the insurance policy? Yeah, I'm totally with you there, Sean, that and the law, section 174 recognizes this, that lot owners are beneficiaries under the insurance policy. And the question that I think Alex was raising, or the concern that I see from Alex's post under the podcast, is that this is a claim that has been lodged without the knowledge of the strata committee. And I am not sure that a lot owner has the right to unilaterally lodge an insurance claim for a policy that's held in the name of the owners corporation. Could be wrong. Let me know if I'm wrong. Yes, that's what I'm going to say on that one. Oh, what came into my mind then was that I know that lot owners often have difficulty individually getting information from insurers. So it's got to work both ways, right? If you are going to be able to lodge an insurance claim directly in your own name as a lot owner, in the same way you should be able to get information from the owners corporation's insurer. If you want copies of other claims, if you want a copy of the policy terms, if you want a copy of the certificate of currency. I have worked with lot owners previously who have said to me, Amanda, we ring the insurer and they say, nah, or the broker, and they say, no, we're not going to talk to you because we take instructions from the strata manager. We take instructions from the strata committee. So it's interesting that maybe that goes one way, but not the other. We're happy to receive claims directly, but we're not happy to give information out. That is confusing to me. Kristen saying, our building insurer has told us we're able to lodge claims directly because we're policy holders. Okay, very interesting. And Sean saying, and they contribute to the premium through levies. Yep, absolutely, Sean, you're right. And Kristen's insurer is CHU. Sean M is saying, I'm more surprised that the insurance company finalized the payout of the claim without getting the excess from the owners corporation without notifying all parties to the policy. Yeah, that's right. And Rena does mention this in our chat, that where there is a large excess like that, or where there is any excess, and if an insurer is paying out, they're going to pay out a sum less the excess. So that lot owner in Alex's example, where the excess was $10,000 and the cost of the rectification work was $13,000, then that owner should have only ever got $3,000. So yeah, I agree with you, Sean. There's something a little bit fishy about that one. Coming back to Vivian's post about a discussion paper that's doing the rounds. It is in New South Wales. It's about short-term rental accommodation. Vivian's going to see if there is a link. Thank you for that one, Vivian. And Josephine saying, who paid the excess? Well, the idea is that the owners corporation pays the excess, Josephine. And I think Sean is saying that if that $13,000 was all paid out to the lot owner, then there must have been an invoice sent to the owners corporation for the $10,000 excess, which might have been when the owners corporation was tipped off to this having happened. So that discussion is happening on the podcast this week. An interesting one there. We've talked about insurance a few times on the podcast, but it's always good to get some concrete examples of what's happening on the ground and to kick off these discussions. It might be time. It might be time for another insurance professional to be invited onto the pod to talk about these issues in particular. In terms of who's covered, who can make claims, who the policyholder really is. Why is it that lot owners seem to be able to make these claims without sign off from the owners corporation? I'm going to put that one on the list and see if we can bring you some more information based on these comments and all of the eyeballs here live today. It is a topic that you're interested in. If you are coming in live, and I can see those numbers ticking up, there are some new eyes here. Please do pop in and give me a hello here in the comments. I'm just going to scroll back and make sure I've covered everybody. Desert is here. I hope I'm saying that right. Good to see you. Hello. I think I've said hello to the Shawns. Hello, Michelle, who is here. All right. What else is happening on the podcast this week? Rena and I continued the discussion about meeting minutes. Have a listen to that. More views coming in on whether you think meeting minutes should be kept simple, a record of what was done, not a record of what was said, applying Robert's Rules of Order and Rules of Parliamentary Procedure. I spoke about that on last week's podcast episode 399. And sought the indulgence to continue that discussion with Rena this week. I'm sure you all have a particular view, especially the few strata managers that I know are here, on how detailed meeting minutes should be. Do we need to go to the level of directors on boards of publicly listed companies, the company secretary who is specially trained to record minutes of meetings, or do we let our volunteer committee members off the hook and keep things simple? Olivia is here saying hi. Hello, Olivia. Sean's chiming in on the minutes discussion, record of what was done, not said. I think you're agreeing there, Sean, that that's what they should be. Shouldn't be a transcript. Rena pointed out that this week. And the other thing that Rena raised was that when our strata managers, who are generally the ones who are taking minutes or responsible for issuing the minutes on behalf of owners corporations and strata committees, when they are being trained on how to take minutes, that was a bit of an assumption, isn't it? If they are being trained on how to take minutes, then this issue should be addressed. How detailed should they be? What do effective, proper, efficient, compliant minutes look like? And Rena questioned whether perhaps there's a lack of training in our space about minute taking. Kristen saying, why was done / resolved? Unless there is a complicated issue and a few more notes, help your owners corporation members understand why a decision was made and how it was made. Yeah, so I'm not sure if you've tuned in yet, Kristen, to the podcast. If you haven't, then you must have been a fly on the wall, because that's what Rena and I were talking about, where you might have some more complicated, ripe for conflict motions on a meeting agenda. You might want to think about adding a few extra notes to the minutes that would otherwise, for your uncontroversial motions, not need to be there. And finally, on the podcast, I shared a win for a member of our community. I spoke about it very broadly, vaguely, roughly on the podcast, because I wasn't yet sure if I had permission to share all of the details about that tribunal win. I have since received permission to share the details, and indeed to share a copy of the decision with you. So I'm very shortly going to take you over to have a closer look at that decision, to find out what it was all about, and to share a copy of that with you. Jeff is posting here asking, and hello, Jeff. I don't think I've said hello to you yet. What happens when minutes are incorrect and are not approved at the next meeting? Yeah, so the minutes are not officially the minutes of the meeting until they are formally approved at the next meeting. So until they are approved, then there are no official minutes of that meeting. And that's why we must have, according to our New South Wales legislation, we must have an item on the agenda for each meeting to approve the minutes of the last meeting. if the minutes are incorrect, then having that item on the agenda is the opportunity then for anyone who was present at that meeting to request an amendment to the minutes, and then to move a motion that the minutes should be amended to include the following changes or additions or retractions, whatever it is that needs to be changed to make those minutes, to turn those minutes into correct minutes. And then you can vote on that motion to amend, and then the amended minutes can be adopted. So that is the process. If anybody thinks minutes are correct, turn up to the next meeting and make that point and see if you can get the amended minutes adopted, or a notation in the minutes of that meeting that the minutes were agreed to be corrected in the following form. That's a lot of words. Hopefully that came through clearly, Jeff. Angel is here saying, hello, yes, thank you. I will use this case for next week. So you know a little bit about this case that I will be talking about, Angel. So you must have had a listen to the podcast. Madeline saying, our current minutes refer to sinking fund instead of capital works. Is this material enough to reject the minutes? Or I would say that might be being a little bit nitpicky, Madeline. You're right that in New South Wales, the current terminology now is capital works sinking fund, capital works fund, I should say. Sinking fund was the term used under our 1996 Act, which came to an end in 2016, or was replaced in 2016. I would suggest that rather than reject the minutes, you might just want to make the point that in future minutes should use the correct terminology. The correct terminology under the current law is capital works fund, and thereafter use the term capital works fund. And Sean is saying, I'm probably not, Madeline, and I'm pretty pedantic. I think I'm with you, Sean. Okay. Before we get into unpacking this case that I have teased for you this week, I want to take you over and show you a little bit of media that has been doing the rounds this week. I've lost all my buttons here. There they are. They've come back now. Now, look, I don't know if this just went under the radar. Maybe I was the only one who saw this. Did anyone see this? Anyone? Anyone at all? Has anyone not seen this? Has anyone been under a rock? Has anyone been on a media diet, which is totally cool? You should go on a media diet every now and then. It's very, very healthy. But if you're in the world and you are watching TV, reading the paper, scrolling through socials, you would have seen this photo this week. This photo of these members of the royal family. It has been released after Princess Kate has been out of the public eye for some time. And it turns out that the photo was digitally altered, raising some questions about whether or not it's even real. Could this just be a mishmash of family members? They were never actually here. They weren't in front of that tree. That wasn't the background. It's all been patched together to hide something, perhaps. Maybe Kate is not as well as the family would want people to believe. And you can see in this, I think this is an SMH article. I'm not going to give you the link to it because you don't need to go and read it. You get it. But this journalist has called this a massive own goal for the royal family. It's caused a lot of suspicion, conspiracy theories, a lot of media attention that the royal family could probably do without. And look, last I checked, even having Princess Kate having come out and said, it was me, I'm the one, I'm an amateur photographer and I did a bit of touching up. It was me who altered this photo. Even having said that, the family still won't release the original untouched photo. So it does make everything look a little bit more suspicious. Now, if you read my email this afternoon when I invited you to come and join us here on Friday Live, I let you know that I talked about this at our City of Canada Bay education session last night. I was able to slip in some learnings from this story. May not seem Strata related. And look, I don't work with royal families, but as I said last night, I do work with Strata owners every day who feel as if they tell me that they are dealing with strata committees that are acting a little bit like the royal family. So what do I mean by that? I mean that we have some committees out there. You might know one. You might serve on one. You might be instructed by one as a strata manager. Committees out there who think that it is better to obscure the truth. Committees who think it's okay to keep owners in the dark, to make decisions in private, closed meetings that happen in somebody's apartment. And there's no record, there's no notice, there's no minutes, there's no opportunity for owners to attend. There are some committees out there that hold back information for fear of telling owners too much, of revealing too much, because it's better. It's better that just we know about this. And we don't want to scare people, and we don't want to have too many people asking too many questions. Committees who tell themselves that keeping things quiet and just between us is in everybody's best interests. Now, the royal family, surprise, surprise, has a bit of a trust problem right now. And I think so do some strata committees. And I say that's because they are completely lacking in transparency. And you may have heard me previously here on live talk about the art of radical transparency and give some examples of how we are putting this into practice in my own community, on my own strata committee, where I have been a member for some years, the steps that we take to ensure that we are engaging in the act of radical transparency so that we don't end up kicking our own goals and ending up in embarrassing, often expensive situations. So last night, a big part of what I shared with residents of the city of Canada Bay was how to ensure their strata committee is being transparent as possible. I talked about 3 steps towards radical transparency. A lot of it is what I've talked about here with you on live before, making sure that owners can have access to records of decision making. Owners can have a seat listening in. They can't vote, can't necessarily speak at a committee meeting, but at least they can be there to attend and listen in. And I explained that from where I sit, there's really no downside to being clear, to being upfront, to being transparent, and making sure that nothing's hidden, pushed under the rug, nothing is digitally altered, as our royal family has made that mistake this week. I see some really interesting parallels there. So that is what I say the royal family has to do with strata. I'm seeing some new names coming in. Hey, Zlata, I see you there. Leonie is here. I also see Baumeister from LinkedIn. Lovely to have you here with us. Not jumping into those specific questions right now, because what I am doing, having shared with you my royal family analogy, going to jump in to our tribunal case that I want to share with you today. Spoke about this on the podcast, and often it is the case on a Friday Live that I like to go deeper on a particular case. And when I have the benefit, the privilege of having owners, members inside our community share copies of their decisions with me, I get really excited, because our tribunal does not often enough share, publish decisions that it makes. And it makes it hard for us as lawyers, makes it hard for you as owners who are trying to work out how the tribunal is applying the law in particular circumstances, in particular cases, and what is new and what is different. And it was a big part of what I discussed with some colleagues last week at our conference of the Australian College of Strata Lawyers. I had lawyers contacting me saying, Amanda, I know you were involved in a particular case because it was in the media. That case sounds like it would be really helpful to my client. Do you have a copy of that? Are you able to share that decision? Always happy to help out colleagues in that way, as they also help me out. But when we have to do that, when you have to personally know someone who was involved in a case to be able to get your hands on a decision that might be helpful to a client, something's going wrong. Something's going wrong within the procedures of the institutions that make these decisions about what should be published and what shouldn't. So, having said that, and I can see a lot of back and forth happening there in the comments, which I will leave you to. Vivian's comment is standing out to me. Fully agree with transparency at all times. I can see Kate saying playing devil's advocate, which I think is about the minutes. So I'm going to leave that one there for you to continue your discussion there about the minutes rather than jump back into that topic. Patricia is saying it's understandable how some committees would be tempted to be less transparent because there are some owners who object to everything and it holds up getting essential maintenance done. However, transparency is always the better course. I'm really glad that you raised that, Patricia, because that is also what I hear from communities who say, we're sticking our necks out if we're going to be completely transparent. We are going to create more work for ourselves. We're going to create more conflict. But I think if you practice transparency in the ways that I teach and the ways that I recommend, which is as simple as convening regular formal strata committee meetings, there's a notice of meeting, there's an opportunity for owners to attend, there's minutes of meetings, then you don't end up in what can be the sticky, difficult situation of having owners constantly have the opportunity to have a say and have a vote. Owners don't have a vote at strata committee meetings. The intention of having these meetings and making sure that owners are aware of them is so that owners have the opportunity to attend. They can't speak, they can't vote, but they can be aware of the issues. Most of them will not take up that opportunity. They just don't have the time, they don't have the inclination. But when they later complain that we didn't know, or how dare you make this decision, or you guys are running this like your own little kingdom, you're the royal family and you do whatever you like and you don't care what we think, then the committee is able to have that protection of transparency and to be able to say, we have meetings regularly. You always know about our meetings because you get notice of them and you're always welcome to attend. The fact that you decide not to attend, the fact that you only raise these issues when we're at the AGM and you want to know why levies are going up or why we're signing a particular contract, that's the decision that you made. But you had the opportunity to attend and listen in and understand what was going on far earlier in the piece. So none of this should be a surprise to you. So ways of dealing with that. But I do, and I think you do agree, Patricia, that ultimately transparency is the better option when you play out the different scenarios. Okay, I'm going to move into this case. Keep getting distracted. So much to talk about. I will share my screen with you. I'm just making sure I've got that set up in the right position. And we have a link. We have a link for you. Team will pop that one into the comments. This is the version I'm going to show you, the version that has been provided to me by the member in our community who successfully led this case, led this case to success. I've just blacked out some personal contact details there, but otherwise the parties to the case, ML Super and the owners of Strata Plan 81779. What I didn't say on the podcast, and which I think is important to give credit where credit is due, the member in our community who successfully represented the applicant in this case is a real estate agent. They are the managing agent for the property. They represented the applicant in this case. This person is named in the decision, and I'm giving you a copy of this decision, so I'm going to name them too. They might be here today still. Jeff Hallam was the real estate agent who acted for the successful applicant owner. Jeff is a member in our community, and in accessing a lot of the resources that are available inside our members' resource library, Jeff has told me that those were instrumental in the success of the application and being able to access me to be able to ask questions and to help lead through some of these issues that came up in the case was very helpful. So thank you, Jeff, for sharing that. And thank you, Jeff, for sharing this decision. And congratulations to you and your client. So investor owner, leaky bathroom. That's the summary. I've highlighted some relevant paragraphs here so I don't drag you through the whole thing. But the primary issue in the case, says the tribunal member here in the decision, was whether the method of rectification of a water leak in a bathroom should be that for which the applicant, owner, contended, or the less extensive, less expensive method proposed by the respondent, Owners Corporation. Less extensive, less expensive. I like those words, and they will ring true for some of you who are attempting to have repair and maintenance work done at your lot, on the common property, impacting your lot. Owners Corporation doesn't want to spend the money. They want to go for the less extensive, less expensive method. So this is a really good example of that situation. This is not a situation where Owners Corporation says we don't have to do anything. In this case, the Owners Corporation said, we acknowledge we have a duty to repair and maintain. We acknowledge there's a problem with this bathroom, but we think there's an easy fix. And it's easy and it's cheap. Applicant says, no, the right fix is not the easy, cheap fix. It's a little bit more extensive than that. Yeah, it's going to cost a bit more money, but that's not my problem. The Owners Corporation has a duty to properly repair and maintain the common property. And that's what I want them to do, says the applicant. So the relevant law, as I pointed out, in New South Wales is Section 106. Those of you who have been in this world here with me for a while will understand how important Section 106 is. That's the duty of the Owners Corporation to maintain and repair the common property. And this is beautiful, okay? I want you to, if you download a copy of this case, we'll take a little screenshot of this here. This is an experienced member of the tribunal. Member Ellis, I believe it was, making this decision. And Member Ellis has given us a gorgeous, gorgeous summary here of the case law around repair and maintenance and what, over the years, the courts and the tribunal have said about this duty, what it means, how it operates in practice. So we've got mention here of the Siwa case, Supreme Court case from 2006. It gets pulled out all the time. It's a strict duty. It's not just an obligation to use reasonable care. The Fernie case, an Owners Corporation is required to repair defects in the original construction of the common property. Proprietors of Strata Plan 159 and Blake, the obligation requires common property to be repaired even if it is not, for the benefit of all lot owners or even a majority of them. Lebrano, the obligation applies even if the Owners Corporation did not cause the damage that needs to be repaired. Ridis, the Owners Corporation is required to restore the common property in good and sound condition and to make the common property and keep it, to make good the common property and to keep it operational. Thu, 2, Court of Appeal, there's no obligation to improve common property if its quality can be maintained by lesser steps. And Glencorie Park Investments, there's a requirement to replace common property fixtures and fittings which are not operating properly and are beyond repair. So these are New South Wales cases. This is New South Wales law, just noting your comment there, Josephine. And I know in Victoria you have a different principle called the benefit principle, which is quite different to how we approach things in New South Wales. So in our forum lately, a number of you, some of you might be here now, a number of you have been asking me, Amanda, do you have any cases that can support my position in the tribunal? Sometimes you're talking to me in the forum about leaky bathrooms. Sometimes it's something a little bit different. But this is a really nice summary of the core repair and maintenance cases that you can wheel out, that you can cite in an application in the tribunal if you are looking to just confirm. Tribunal members should know these things, but if you're self-represented and you're looking to just confirm or remind the tribunal of where these legal principles come from, then you got a nice list there from Member Ellis. I'm going to keep moving down to the applicant's case here. The applicant said that the water leak had been ongoing for 15 months, was not addressed or inspected for 4 months after it was raised. It was contended that the sequence of events was that the water leak was reported November 22, an inspection in December 22, another inspection in April 2023. It's now March 2024, just pointing that out. The respondent, who is the Owners Corporation, got a report. The report suggested the waterproofing membrane has failed badly. And there was also a waterproofing report from another group in relation to the water stop angle at the doorway. Now, I'm not going into all of this detail, but ultimately the Owners Corporation proposed that they use a company called Tile Rescue, who are not waterproofers and only intended to remove and replace the grout and seal the tiles, which was said to be a temporary measure. And a submission was made that the respondent had obtained some advice but continued to disregard that advice. And I think the submission was, you've got these reports up here from these waterproofers who say that the membrane has failed badly and there's a waterproofing report about what needs to be done. However, you're preferring, Owners Corporation, the opinion of Tile Rescue that says you can just seal it. Just seal it. That is the less expensive, less extensive solution that the Owners Corporation was proposing. Now, the Owners Corporation also made a submission about its financial position and its budget in relation to capital work. And the Owners Corporation said that if the owners proposed expensive, extensive method of rectification, which you can imagine was remove the tiles, give us a new waterproof membrane, relay new tiles, fix the levels to the extent that there's a problem with the levels. If that proposed method was followed, it will have a significant financial impact on the Owners Corporation, both in the current financial year and in future financial years. On the basis that we're talking about 80 bathrooms, that's $2.4 million if it's going to cost us $30,000 per bathroom. So that's the Owners Corporation saying, this is going to cause us a huge expense if you, tribunal, decide that this method of rectification is the one to be followed instead of our proposed option to simply seal the tiles. The tribunal ultimately found that the tile rescue, the sealing method of rectification, did not address any of the identified issues of the water leak. There was an insufficient fall in the floor tiles. There was failed waterproofing. There was deficient water stop angles. This was all in an expert report that the applicant had obtained and the applicant had filed. Really, really important. The applicant had expert evidence to say that the tile rescue sealing method would not work, and the tribunal accepted that evidence. That method does not address the effect of water ponding and draining, may not stop the egress of water. Accordingly, said the tribunal, that method does not address any of the causes of the water leak and will at best only address one of the effects. As a result, that method cannot be considered to be the minimum necessary level of work. It is a deficient method of rectification. There was also an issue that the Owners Corporation said, we've done this sealing of tiles by Tile Rescue in other apartments, and that's worked really well, and that solved the problem. However, you can see in this paragraph here, the tribunal found that that was inadequate evidence. There was just a spreadsheet that said money had been paid to Tile Rescue for this work, and there was no evidence that the work done was successful. Rather, there was evidence that the applicant had submitted that said there was an instance where the method, the sealing method, was not successful, and the tribunal was more inclined to believe that that method was not appropriate on that basis. The tribunal also made really clear, even if there was evidence of success in other cases with simply sealing the tiles, and even if it was relevant that the Owners Corporation doesn't have sufficient funds to meet this expense, the tribunal says here, the financial circumstances of the respondent do not constitute a defense to a breach of the obligation to maintain and repair common property. So we've always said this. Many of you come to me saying, Amanda, the building won't do it because they say they can't afford it. They want to do it in stages. They want to raise the money in 2 years' time. After we do the lift upgrade project, they'll do it then. They think that's a good enough excuse. The cases are clear. And member Ellis here in the tribunal is confirming this. The financial situation of the Owners Corporation is irrelevant. They don't have the money. They've got to find the money. This is a strict, absolute, immediate duty that they need to meet. When it becomes apparent that there may be insufficient money in the Capital Works Fund, it becomes necessary to revise the Capital Works program and/or impose a special levy additional to the annual levy on each lot, which is usually paid quarterly. Really nicely put, really put in a really understandable way. I don't think we see this often enough in the tribunal. The decisions are out there. They're being made. They're being made every day, I'm sure, in favour of lot owners, but we don't always get these copies of them. There's been a clear breach of Section 106 by the Owners Corporation in failing to maintain and repair the common property. It took the respondent, Owners Corporation, an unacceptably long period of more than 6 months to investigate. It failed to follow advice from no less than 3 sources. It proposed a method of rectification which does not address any of the causes and does not address all of the effects. And the proposed method was not only contrary to the advice it received, but overlooked the fact that it had been found to be unsuccessful in another lot earlier. The tribunal is satisfied that it should avail of the power conferred by this section in the Act to require work to be done to rectify the leak, which work can apparently be completed by the end of April this year. In addition to the order to get the work done the way that the applicant proposed, there was also an order for the Owners Corporation to reimburse the applicant owner the reasonable costs of alternative accommodation for the period when it said the occupant is unable to use the bathroom. So I think it was going to take about a few weeks to do the work. Owners Corporation has to pay the lost rent that the investor might be experiencing, or pay to put up the tenant in another place, whatever it is, the arrangement that is worked out there. And there was also damages of $1,400 based on a quote for carpet replacement. The water leak had come out and damaged the carpet, and the evidence was that it would be $1,400 to replace that. So costs damages award there. As for costs, the parties have been told if they want to make a claim for costs, they can, and there's a timetable there set for a cost claim, which looks like it has yet to run. That case you can have a read of, link here for you. Special thank you to Jeff Hallam for sharing that with us. He was the successful representative, non-legal practitioner, real estate agent, representing his client very well in the tribunal there and sharing that case with us. Lots of comments here coming in. Kristen saying, so the argument that it's too expensive is too bad, so sad. Yep, indeed. And Kristen saying every bathroom should be budgeted for. Another topic that came up in my discussion with Rena on the podcast this week, where she said, Amanda, is that really fair that owners who have original bathrooms that may have been there for 20, 30, 40 years, those bathrooms, inevitably, the membrane fails and they start to leak. Is it really fair that the Owners Corporation should foot the bill for that? I'm in the privileged position of being able to say, I don't deal in fair. I deal in what the law is. And sometimes the way the law operates in practice might not seem fair, but that is what it is. And where there are, Kristen saying every bathroom should be budgeted for, I would add a clarification to that to say every bathroom that is original, that's still the Owners Corporation's responsibility because it is original common property, yes, should be budgeted for. Some buildings you don't even know how many bathrooms have been renovated and how many haven't. So if a lot owner has renovated their bathroom off their own bat, their own idea, want to improve their property, want to invest, all excellent things to do, then that renovated bathroom is no longer the responsibility of the Owners Corporation. And hopefully there's a bylaw in place that makes that really clear so there can be no doubt about that. Patricia's saying, great to know. Patricia's also saying short-sighted opinion by the Owners Corporation as even more serious damage can occur to common property by water penetration. Yeah, absolutely. And this is the thing, and I've seen this on numerous occasions where what starts as a small water leak and an easy fix, when left unattended, ignored for whatever reason, and sometimes it's unattended and ignored because the Strata committee doesn't get along with the owner or sees the owner as a bit of a serial complainant. There's a personality clash. The owner might not be so great at communicating in a way that is calm and considered and acceptable or reasonable to the Strata committee. So that owner just gets ignored. The problem gets worse. The water leak becomes more persistent. Water is like that. The internal damage to the lot becomes more serious. We've got carpet damage here and now a tenant that has to move out for 3 weeks for that repair to be made. Olivia saying, yes, please. I think, is that yes, please to more cases? Because I just like reading this kind of stuff. Kate is saying, we did one in our building that was leaking and not done right. And now before the commission for inspection and told this could take months. Fair trading before 1 December 23, closed the book on it without inspecting. Interesting. Let us know what you mean there, Kate, by before the commission for inspection. Is this an original building defect? And is your Owners Corporation involved in a complaint against the original builder Leonie is saying, I pray I get member Ellis at my next NCAT hearing. Yeah, very considered, well written decision, I think. Some of our members are more thorough than others when it comes to writing their decisions, but we are grateful when we can get decisions like this, which legally, my point of view, makes a lot of sense. Kate's saying senior member Sargensen is very reasonable also. And Jeff, you are here, Jeff. Great to see you. Jeff is saying, thanks, Amanda, for your support and information. And well done again, Jeff, for successfully representing your owner client. That must be a happy camper there for you. It can be done. As I said on the podcast, Jeff is living proof, and there's many other examples in our community of owners who are self-representing in the tribunal and are achieving successful results just like this one. And it is these repair and maintenance cases that are, to be honest, a bit rinse and repeat. The law is well settled. You know what it is that you need to prove. The debate is sometimes about the method of rectification. Sometimes, if an owner's corporation is not well advised, the debate can be about whether they're responsible or not. Either way, those positions can each be, in my view, easily answered with reference to the law and if you've got the right evidence. So don't be afraid to take it on yourself if engaging a lawyer is not something that is a possibility for you, or just not something, or something that you just rather not do. Or, as was the case here in this situation, the tribunal might not allow lawyers to appear. So I remember chatting to Jeff about this. The owners corporation had sought leave to have a lawyer appear. I think the owners corporation had actually claimed on their insurance policy, and they had an insurers panel lawyer all briefed up and ready to go. And Jeff, on behalf of his client, objected to that and said, no, I don't think we need lawyers here. I can handle this for my client in the same way the owners corporation, via its strata manager or committee member, should be able to handle this. And the tribunal agreed and did not give leave for legal representation. It does happen. It does happen in cases that I'm involved in. And then I stand behind, figuratively, behind the owner and support them as best I can if they still want that support. Angel saying, yes, this is so similar to my matter. I thank you so sincerely. Excellent, Angel. I'm not sure if you're the one who's been posting in our forum wanting help with some relevant cases. Kira saying, what happens if delay in repairs is because owner has not brought it to OC? Should the owner have to contribute to correcting extensive repairs as a result of delays? Yeah, look, if you don't know about it, then it's hard to criticize you for it. But the fact is that as soon as it comes to the owners corporation's attention, you do have to jump on it. You do have to be looking at what is needed to repair and maintain it, and you do have to attend to it. Where lack of notice is going to be an issue is if the situation has perhaps gotten worse because of the owners corporation not being aware of it. And if the lot owner had notified you earlier, then perhaps the damage might not have been as extensive. I can see an argument in that situation where the owners corporation might not be responsible for consequential losses, especially, and I have been involved in a case like this before, especially where contents are damaged and there is evidence that the owner knows the contents are being damaged, and yet the owner doesn't tell the owners corporation about the problem and doesn't move the contents. So something's sitting in a wardrobe getting moldy and it can be moved to another part of the property, and the owners corporation is not aware of this, hasn't been told, but then finds out that they've been sitting there getting moldy for 6 months, 12 months. There is a real argument there that that owner should have mitigated their loss. That's the legal term that we use, mitigated their loss, and could have easily moved that contents out and could have salvaged it. So it might be a situation where the owners corporation won't then be responsible for replacing that damaged contents. Might have been you, Kira. I don't know if you were at the event last night, but I got a very similar question at the City of Canada Bay event last night during our Q&A time. And I said, look, that's a hard one, and it really depends on the particular facts of the case. When you're involved, if you're an owners corporation or committee involved in those kind of cases, you really should be getting some specific legal advice to assist you with those that are not as black and white. All right, lots of comments here, and I think bit of back and forth that's happening there in our Facebook comments. I am going to wrap it up here for you. Look, I had said to my team, we're going to wrap up early today. It's going to be about half an hour, 45 minutes. Here we are at 5 o'clock. That is how much we love talking about this stuff. I so appreciate you for being here, for sharing your experience, for sharing your cases with me. I have to go back and have a closer look, but I think there was one or two of you who said, I've got a case that I can share with you. You're always welcome to email me, amanda@yourstrataproperty.com.au, if you have something to share that you think others will benefit from too. We all have so much that we can learn from each other, and this is the place to be if that is what you want to do, to learn to improve your experience of strata living. Thank you all for being here. Have a fabulous weekend in Strata. See you next time. Bye.